Hi, I'm Michael Bowman, one of the partners at Anderson Business Advisors. Since the pandemic, we've been really inundated with questions about estate planning. People are starting to realize that, hey, you know what, maybe I'm not going to live forever and I need to get a plan in place. One of the questions that really comes up a lot when we start diving into estate planning is, do I need a will or a trust? Which is better and which one do I need? And so, you know what, let's go ahead and dive into the information and let's find out. The first thing that I run into when people get into estate planning, when they start talking about estate planning, is they're finally realizing that they put this on someday island, and basically it's time to address it. It's kind of been a interest of mine, or kind of a question of why do people keep putting this on someday island until either A, it's too late, or B, something tragic happens in their life. One of the things I found is people just think there's plenty of time. The pandemic made us realize that, hey, there is finality to life. And so that excuse isn't really applying anymore, and people are actually starting to take hold of it and saying, hey, listen, life is finite and I need to address this. The other answer that I get at times is, hey, it's really uncomfortable to think about me passing, me not being there for my children. What's going to happen, and how are my assets going to be handled? It's just very uncomfortable. And then when they start thinking of their assets, they think, wow, this is going to get complicated fast. It's kind of fun to work with clients and show them that, hey, you know what, it might be a little complicated on the surface, but once we start looking at the tools that we can use, there's tools that are designed to make it less complicated. And so it's less complicated for you, but the important part is it's less complicated for your heirs too. And that's something that's really important. And that gives a lot of my clients a lot of peace of mind, knowing that they have everything set up in a way that's efficient, and also takes a lot of the hassle out of, the hassle, the worry, and a lot of the work out for their heirs. One of the other things that when you start looking at the process of courts, it's kind of becoming intimidating. One of the things I'm going to share with you guys today is that we don't need to go through probate. The probate court system is set up for those who don't have a plan or have a simple will. And again, when we start avoiding that probate process, the high attorney costs go out the window. In fact, what's really, really neat is a lot of times with my clients, what I'll do is I'll show them that, hey, you know what, you might be able to save money up front with a simple will, but in the end, in the long run, after a probate costs, then you will actually pay more using a simple will than a trust. Trusts also have the reputation of being very expensive. When we look at trusts, they used to be about $10,000 to $12,000, and now they're down to around $2,500 to $3,500, depending on the type of trust that you need. And so the costs have come way down. Why is estate planning important? First of all, it's important because we need to design the plan ourselves, and we need to make sure that it gets implemented. The one thing that I talk to my clients about is, hey, you've worked really hard and acquired a lot of assets. You've sacrificed a lot for those assets, or sacrificed for a better future. Don't you want to control it? Don't you want to be able to pass it down to your heirs, and then have it come down to who you want and when you want it to come out to them? The other reason why you really want to make sure you have a proper plan in place is the simple fact that if you don't have a plan, then the state that comes in and decides it. The state has a bunch of rules regarding people who we call die intestate. And so, the perception problem that we have also is, I don't have anything. I don't have enough to actually warrant a trust or a will. People's perception of what they own is a lot. Oftentimes, when I speak to a client, is different from when we start getting into their assets, because we start looking at, they got their home. In the last few years, we've seen an incredible amount of equity built in homes and real estate. They've got their cars, the collections, and the family heirlooms. Now, this is one of the things that I have to point out. While the family heirlooms and the collections may not be have a ton of value or perceived value, they've got a lot of sentimental value. And this is really important. It's really important to plan for these items. I've seen many families destroyed, and the relationships destroyed within a family, over simple collections of figurines, or of things that have perceived value. And it's really disheartening to see, in particular, one of the situations, some sisters who, they've been best of friends for decades, and all of a sudden that family relationship got pulled apart by a physical item. The other thing that the real estate, like I mentioned, in the last few years, property values have really increased. And so we really have to make sure that we design a plan around our real estate, what happens to the real estate, how it's dealt with, and then we want to make sure that we capture any of the value that we can. And that, again, it goes to benefit people's lives as opposed to pulling away from them. Our checking accounts, our savings accounts, life insurance, our retirement assets, we still need to plan for these, even though there's a designated beneficiary, because sometimes we have family situations that we don't want the person getting the money right away, and we need to design a plan that's actually going to take care of that. And then just simple business interests. A lot of my clients are business owners, and they've built businesses over the years. We need to make sure that there's a succession plan put in place. And so all of these, when you start thinking about it, wow, maybe I do have a lot of assets. And so we need to make a proper plan for those, because without it, the state's going to decide, and it's going to go through probate. And let me just kind of go through what probate is really quickly, because I think a lot of people wonder, hey, well, I keep hearing probate and it's always in a bad connotation. The probate process is basically a court process set out to basically get the creditors paid, and then whatever assets you have left over, a judge is going to decide where that's going to go and where it's going to be split, or a will is going to decide that. But the probate process is basically a proving process, getting creditors paid, and then whatever's instrument it needs to be proven in the probate process. The problem with the probate process, as opposed to things that are kept private, and that's a lot of my clients, they like to keep their wealth private. This all gets exposed because it's a court proceeding, it's a public process. Because the court is actually deciding things, and so it needs to be held in the record. And so those are attainable by people who do a little snooping. Other problem with the probate process is the length of time that it's taken. Before the pandemic, it was about 18 months was the national average. Since the pandemic, I believe that's crept up to about more like 20 months to 24 months. The problem with that is while the probate's going on, the family has to wait for those assets, and foreclosures, repossessions, things like that happen. Tying in the real estate that people have acquired over the years, if properties are held in more than one state, you have to open up probate in each of those states. You think one attorney is expensive, get a couple of us in the room, it gets really expensive fast, and thousands of dollars of legal fees will be spent. All right, let's get a breakdown of a will versus a trust. Basically, a will is a simple instrument. $800 to $1,000 is what they're going to charge you. We don't even do wills anymore because it's too simple. It doesn't control enough. We want to be able to control things from the grave. Basically, a simple will is just going to go ahead and direct who gets what, and the court's going to say, yep, that works, and then makes the distribution, or has the executor make the distribution. Like I said before, a will has to be proven, and so therefore it has to go through the probate system, and the probate system, again, costs thousands of dollars of fees. Basically, what we also want to look at is a trust. On a trust, the trust is basically, just think of it, it's a living trust you hear. Well, it lives on. While you may pass away, your trust lives on. A trust is going to name the person to control your estate and how it works. It was so fun to actually learn about trusts almost 20 something years ago. Wow, that makes me sound old. But when you look at a trust, it's this vehicle. In the eyes of the law, it's a separate being from the actual individual. But inside the trust document, it's going to name the individuals who are in control. Because it lives on, it doesn't need to go through probate because it's still living. The trust is going to direct when things get distributed out, how they get distributed out, and who they get distributed out to. And so since there's not attorneys involved, since there's not a big probate process involved, it saves thousands of dollars in legal fees. So you're already seeing where I'm going with this. Back in the 70s, 80s, and 90s, I believe that, hey, wills had a place in the system. Nowadays, with the costs coming down, with the ability to control more, and keeping attorneys and the public out of our lives, we go towards a living trust. Now, to break down, when people hear the word trust, I feel like a wall comes up. I feel like a barrier comes up, because when they think of trust, they think of the Rockefellers, the Kennedys, and it's not for them. Well, there's two types of trust. There's their irrevocable trust and irrevocable trust. A lot of the trust you hear about, they're irrevocable trusts. And the living trust is a revocable trust, meaning there's a lot of flexibility. We can put assets in, we can take them back out. If things change or circumstances change in life, we can go ahead and make those changes right away. We can that document, that trust and the rules will evolve over time until you pass away and then it becomes locked in. The other thing that confuses people or maybe intimidates people is the different parties to a trust. When you put an asset into the trust, you're called the grantor. When you're controlling the trust, you're called the trustee. And then when you're benefiting from the trust, you are the beneficiary. That should be the simplest one. When you pass, you will list inside the trust document a successor trustee, and they'll take control. You're still in control through them because you've written down a bunch of rules to the trust, who gets what, when they get it, and then you deal with any circumstances on the behalf of the beneficiaries. It's really neat because why I like a trust so much opposed to a simple will is the level of control you can have with the living trust. Something that's really important to me. I'm a father. My wife and I, we have two kids. We have a 8-month-old and we have a 4-year-old. Very different type of individuals. We're really not sure how my daughter, who's 8 months, how she's going to turn out. One thing that is congruent with both my son and my daughter, or our son and daughter, is the simple fact that we don't want them to get the money right at age 18. We've seen too many problems occur when a child gets the money at the age of 18. You hear a lot of times about the drug problems, things like that, people being taken advantage of. I really think of it from motivation to go ahead and have them achieve their own desires and goals. If maybe my son or my daughter gets the money all at 18, maybe they won't be so inclined to achieve their own purpose or their own goals, achievements, things like that. And so the way we have our trust set up is basically we have a periodic distribution schedule. This is probably the most popular among my clients, is they want the money distributed over time. In the way that you're looking at it here, 10% at age 25, why I like that so much is that generally they will have to have gone through college. Maybe that 10% is going to be used to pay off some debt or start their investing. They can invest with the 10% and build on it. It's not all the money in the world. It's not all the money in the trust. And so it still motivates them to go ahead and achieve their own goals and desires and their achievements. And so it's really something that's important to me. I've gone to school with many of kids who had a trust fund. And the problem with that was they thought it was all the money in the world. Well, decades later, they went through all that money in the world, and now they have no real life skills. They don't have professions, things like that. And I've seen it be a real detriment to children. The next distribution comes out at 30, and then 35 and 40. If you notice, it's a backloaded distribution schedule. The reason why in our case is we really, again, want them to achieve their own goals, desires. It also acts as a prenup because while they might take inheritance and split it with their spouse, a divorce, that money, whatever's been distributed out and commingled, could be subject to the future ex-spouse's claims. And so what we want to do is we want to make sure that that inheritance is protected. And so by backloading it, they can get their lives in order, make sure that congruity in life is something that they can achieve, and that we're not having to split one half of everything that we've worked so hard for with a future ex-spouse of one of our children. Like I mentioned, as our children's life evolves, that they can go ahead and we can change the trust. I can alter all these ages that distributions get made out at. And that's something that's really important to me because maybe I've got a very, one of my children become very financial, great financial stewards. The great thing about that is maybe I want to go ahead and make distributions out to them earlier. I can do that. And the neat thing about trust is you can love your kids the same, but treat them differently. And so if there's problems I need to address, I can go ahead and do that inside the trust document up until I pass, and then it becomes locked in. For special needs beneficiaries, we can go ahead and create provisions that protect their benefits. And then also one of the things that has been something that has been really on my clients' minds is protecting the beneficiaries from themselves. And what I mean by that is making sure that the money's not used for drugs. We've had problems with, certain clients who have kids that have drug problems, and we've seen deaths occur because they got the inheritance and spent it on drugs and overdosed. We can put provisions in there to make sure that they are clean. And if they are having problems with drugs, then the money can be used to go ahead and get them into rehabilitation training and kind of the best of both worlds. If they test clean, they get the money. If they test dirty, then they get into rehab and hopefully change their lives a bit. The other thing we can do is we can have a provision in there that can set the money aside into a separate property trust and protect it from divorces, creditors, things like that. And so there's a lot of flexibility, a lot of benefits to using a trust. That's why we don't go over and use a will anymore. That's why we've evolved a society, using wills now into trusts, and it's simply for the control. And the control is something that I really want to make sure that whatever my wife and I put together, that it benefits our children as opposed to take away from them. Now, when I talk about a trust, I feel a little bit like we're not addressing the entire problem, because a living trust, while it's going to control your estate, there are other documents that you must have. And this is overlooked by a lot of attorneys. They might create the trust, but then they forget about the other things in life that we need to deal with when we're talking about an estate. The first thing we need to do is we need to have a backup provision. What we use in our case is we use a pour-over will. Basically, we understand our clients' lives get busy, and they might set up the trust, fund the trust by putting assets in the trust, signing the trust, like I mentioned before. But then when they acquire new assets, they forget to go ahead and put them in the trust. Well, what we do is, if that happens, what we have in there is a pour-over will. And the pour-over will is going to go ahead and take those assets, put them into the trust, distribute according to the rules of the trust. The other things that are very important, we've seen this in COVID, is we need medical care power of attorneys and financial power of attorneys. We've got calls by family members, and their other family members were in the hospital incapacitated, and they needed to be able to control their lives with medically and also financially. And once you're incapacitated, it's too late. You have to have a court order. So we need medical care power of attorneys, financial power of attorneys, physician directives. We want to be kept pain-free, artificial hydration, nourishment, things like that. Very important to make those decisions. It's called a living will. This needs to be part of your estate plan. And then if you have children underneath the age of 18, you need to have a declaration of guardian, making sure that you're choosing those who are going to be taking care of your children. Some of your family members want to take care of them. Some of them don't. Some of them fight at a time where they should be coming together. They're fighting to who's angling to be able to take care of the kids. Everyone thinks they're the best to take care of them. And so fights do incur at a time, again, where families should be coming together for the children. They're pulling apart. The other thing, like I mentioned, is the heirlooms. We need to have a document that actually states and sets forth who's going to get the heirloom or the collection, so that there's no family fighting involved. Again, grieving and greed goes together. The other thing we can do for our families is a simple fact that we can go ahead and outline whatever ceremony, whatever memorial instructions we have, we can go ahead and outline and take that burden off of our families. So that is very, very important. All of these need to be in your estate plan, and make sure that it's complete, not just a living trust, but it needs the supporting documents. Now, when changes in life go on, so we need to make changes. We need to go ahead and update our medical care power of attorneys. If we've adopted children or had new births, we need to go ahead and address those provisions, make sure they're included. Now, if you don't do that, we do have catch-all provisions that will go ahead and address it. But what we do is, every 3 to 5 years, take a look at changes in your life and go ahead and make updates to your estate plan. What to do if you already have an estate plan? I would go ahead and pull it out and take a look at everything I have here, your beneficiary designations, your power of attorneys, schedule of gifts, living wills, and your final instructions. Make sure that it's kept up to date. Again, I would go ahead and do it every 3 to 5 years. You really don't need an attorney involved in this. It's all of your personal decisions. And so you can do this. And again, just make sure that the documents are kept up to date. If you move states, we need to go up and update your medical care power of attorneys and your financial power of attorneys. And so those are the things I wanted to cover today. Again, wills used to be good, and now we want to use a living trust. If you have any questions, please look at in the comments below, and you can go ahead and click a link and get a consultation scheduled with our firm. We'd love to speak to you about your estate planning, and I wish you guys the best of success. Thank you.